Yeah, welcome. You have seen that our organizers, the organizers of this conference, are so skeptical that they don't believe there's any such thing as a history of presidential power, but only in the plural, histories of presidential power. And we will, I guess, add to those histories now. I want you to know that, as I said there this morning, and I think I'm not mistaken, there was not a single reference to the term separation of powers, or separation of power, as I prefer to put it, but not a single one. We talked about the presidential power all morning, but not about separation of powers. And I guess this panel will change that to some extent because of its topic. We were so nervous about being able to keep up with a splendid performance this morning that we decided to double the number of speakers that might give us a somewhat better chance to survive. We will proceed, and then we have done something else that in the chaos of the morning panel was clearly not the case. We have organized ourselves, or the speakers have organized themselves in such a way that they are sitting actually in the sequence in which they will be called upon, and Ilan will be the first to begin, and then we will proceed from there.
Thank you. Can you hear me okay? I delegated myself the position of going first just to make sure that I had time to get in everything I wanted to say. And whatever's left, you guys can share, divide up. But so my paper is called In Search of Prerogative. It actually came out in the Duke Law Journal in October 2020, just as COVID hit. So this is actually only my second time presenting that paper in public. And so the paper is about the meaning of the phrase, the executive power, as I hinted earlier this morning in the vesting clause of Article 2. So I want to lay out the overarching thesis and then argue that evidence from the first and second Congress, so yes, I'm cheating a bit by including the second Congress, support my thesis. So there are currently, I think, two competing approaches to understanding the grant of the executive power to the president as a substantive grant of power. We heard both this morning. The prevailing view among formalists and originalists, I think, was articulated by Michael McConnell, is that the executive power refers to all royal powers and authorities possessed by the British monarch circa 1787 and any other powers that are, I guess, executive in nature, subject to the assignment of such powers away from the president in other grants in the Constitution. So thus, this grant of executive power contains this residuum of executive-type powers. Julian Mortensen, John Harrison, Matt Steilen, and others claim that the executive power is not a residual grant of royal authorities, but is instead a grant of a single power, the power to execute law. According to Professor Mortensen, at least, he even used this word earlier today. I think this is a very thin power. It's the power to carry Congress's laws into execution with whatever tools, officers, and other restrictions that Congress chooses to create. So on this reading, for example, I think Congress should be able to create removal restrictions on executive officers, though Professor Mortensen is quite open-minded about this. Any missing foreign affairs powers would be supplied by Congress via the necessary and proper clause. Okay. I concur in part and dissent in part from both of those views. I argue that neither version is quite right. So my claim is that the executive power was indeed a single power. It was only the power to execute law. But there is a thin version of this power and a thicker version of it. The thin version was articulated by Professor Mortensen earlier today. The executive power is entirely defeasible. Congress can, for example, assign specific duties to subordinate officers and perhaps insulate them from presidential removal. The thick version, the one my paper advances, suggests that the executive power is the power just to execute law, but that power includes incidental, derivative, and component powers necessary to effectively exercise this executive power of law execution. For example, and principally, the power to appoint, to direct, and to remove executive officers. So my claim is that this thick understanding of the executive power to carry law into execution is actually the only reading of Article 2's vesting clause that seems to be consistent with the textual evidence, the evidence from the framing and ratification, and with most historical practice, consider first how the two competing theories we heard this morning each have some possible and possibly glaring shortcomings. I think the residual thesis that we heard is more consistent than this thin law execution reading with some historical practice, like the early debates over the removal power, maybe some presidential practices in foreign affairs. But I think otherwise this residual reading is quite implausible based on the textual evidence that Julian and others have laid out, and evidence from the Constitutional Convention and ratification. I don't want to talk about the textual evidence. I think it's somewhat ambiguous, but overall supports what Julian said today. But on top of that, I wanted to talk about briefly the Constitutional Convention and then debates in the First and Second Congress. Let me just highlight 2 points about the Constitutional Convention. First, and this is well known, and we heard it this morning, the convention's instruction to the Committee of Detail, the actual vote that is, right, on the convention floor, was to grant the president only the power to execute law and to appoint officers not otherwise provided for. Professor McConnell acknowledged that a residual vesting of all executive type powers requires us to believe that the Committee of Detail ignored that instruction. Second, and this is what I really want to start focusing on, and I hinted at it in my question earlier, the power to erect corporations was specifically rejected in the convention, most likely because the delegates didn't want the national government to have this power, although to be sure, some like Wilson might have thought that enumerating it was unnecessary because we have the necessary and proper clause. The point is only that this power to erect corporations was a prerogative power. It's right there in Blackstone. If the residual vesting thesis is right, the conclusion, I think, must be that while voting to deny the national government this power, or at least talking about this power, not a single delegate was aware that that power might belong to the president anyway, by virtue of the vesting clause. That just seems totally implausible to me. Now let me bring in the Second Congress, and at least Alexander Hamilton. He was aware of this when discussing, in his opinion on the Bank of the United States, he was aware of this fact about the historical prerogative. Yet he never once suggested that the power of incorporation at a minimum belonged to the president under this residual vesting thesis, which would have been an argument that he would have made because he wanted to incorporate the bank. Hamilton said, in his opinion, that the importance of the power of incorporation has been exaggerated, will further appear from tracing its origin in England, whence our notion of it are immediately borrowed. It forms a part of the executive authority. If Hamilton really believed in this residual vesting thesis, he would have said something right then and there, but he didn't. In his Pacificus writing, by the way, which came 2 years later, he did make the residuum theory, but this was sort of an afterthought. It was an alternative argument. Okay, let me put Hamilton aside. Let me talk about Madison, and then I'll be done. I think Madison, in the removal debates in the First Congress, also supports the law execution reading, even though the residual theorists often also invoke Madison. The removal debates are entirely about law execution. The president cannot possibly execute the laws alone, so the president must have assistance. The power to appoint such assistance was therefore part of the executive power to execute law. Blackstone, by the way, we've talked about him before, said that the king has the power to create courts and judges to assist him in exercising the executive power of the laws. Madison and Ames and others argued the same thing. A residual grant of executive power simply has nothing to do with the issue that they were confronting. Here's what Madison said. The Constitution affirms that the executive power shall be vested in the president. Are there exceptions to this proposition? Yes, there are. The Constitution says that in appointing to office, the Senate shall be associated with the president. Have we a right to extend this exception? I believe not. Madison isn't saying war and treaties and everything else would belong to the president if it weren't distributed away. All he's talking about is appointments and removals, part of this power of carrying law into execution. I'll say one last thing, actually. Jefferson is also invoked. There's this letter that Mike Ramsey is an expert about. There was a debate in the Second Congress over whether the Senate could negative the grade of an ambassadorial appointment. Thomas Jefferson said no in a famous letter. He said all executive powers are vested in the president with only enumerated exceptions, he said, and so the Senate could only negative the appointment. But again, we're talking about appointments. In my view, appointments can be seen as part of the power to execute law. And so my claim here, and I'll just jump to the conclusion, is that this thicker reading of the executive power to carry laws into execution, one in which it doesn't include this residuum of royal prerogative powers, I think it is the most consistent with text, structure, and history under this reading. I think the president has more power in the domestic sphere, appointment, direction, removal, but than the thin law execution account, but I think probably the president has less power in the foreign affairs space than under the residual account. And that's what I wanted to say today.
Thank you very much. Thank you. Mike?
All right, thanks a lot. Thanks so much to the organizers for having me here. It's great to be back at Stanford. I went to law school here many years ago. They didn't have buildings like this when I went here, but it's still great to be back and see all the new things. I also want to apologize a little bit for bringing this paper to a history conference, because my paper's not really a history paper, as those of you who read it have seen. In fact, you might even call it an anti-history paper, because it is about the text of the acts the Congress passed in 1789. And it reflects a lawyer's perspective, I think, a law professor's perspective perhaps, but nonetheless a lawyer's perspective, that if we want to get an idea of what the Congress was doing, we ought to at least start with what they actually did, the only thing they actually did collectively, which is to pass these acts. So that's what I want to focus on, is the text of the acts that they passed in 1789. And when we do look at that, what we find is that there are a lot of things they didn't do. And that's really what I want to focus on. So I want to talk about the three most relevant acts from 1789. First, Congress passed an act creating the Department of Foreign Affairs with a secretary and a chief clerk. And this act said nothing about powers and duties of the secretary or the clerk, except that the secretary would follow the directions of the president in foreign affairs. Did not give the secretary any particular powers or duties apart from that. And crucially, it didn't give the president any powers in foreign affairs either, and no other enactment of the first Congress in 1789 gave the president any powers in foreign affairs at all. In very sharp contrast, I might say, to the Articles of Confederation, which also had a foreign affairs department, and the act establishing that department had a very long list of powers and duties of the secretary, which the secretary was to exercise expressly under the direction and with the approval of Congress. All right, so that's the first thing they did. Second thing they did was they passed a very similar act, very much in parallel, establishing the War Department. Again, they established a secretary, a chief clerk. They said that the secretary would follow the directions of the president in matters relating to the military, and they didn't say anything else. They didn't say didn't describe any powers and duties of the secretary at all. And they didn't describe any military powers of the president. They didn't give the president any military powers or duties in this act or in any other act. Again, in very sharp contrast to the Articles of Confederation, which also had a War Department and also had a secretary, and the secretary, like the Article Secretary of Foreign Affairs, had a long list of powers and duties in the establishing act. The third thing they did was they established the Department of Treasury. Now, in contrast, in the Treasury Act, they did establish powers and duties of the Secretary and a number of subordinate officers in the Treasury Department. It was not simply that these people were to follow the directions of the President, but rather they had a specific set of powers and duties. And then the final thing that these three acts had in common was removal. And to mention the removal just briefly, each of these acts had the somewhat ambiguous language, which you'll hear more about, I'm sure, that said that the chief clerk would take over the records and other papers of the department in the event that the secretary was removed by the president. It didn't say anything else about under what circumstances the secretary would be removed. And even more importantly, to my mind, it didn't say anything about how the subordinate officers, the chief clerks and the other subordinate officers in the Treasury Department, would be removed. Now, what do we make of this all? I think the best explanation here is that Congress thought that the president had independent power in foreign affairs and in military affairs from the Constitution itself. That's why Congress didn't specify any foreign affairs powers for the president or the secretary. And that's why they didn't specify any military powers for the president or the secretary. Those powers came from the Constitution itself. In contrast, the president didn't have independent constitutional powers over financial matters, or at least it wasn't obvious that he did. And so the Congress did have to specify powers and duties in the Treasury Department. Now, why did Congress think this? Well, it's easy to see, I think, why the Congress thought the president had independent power over military matters. That comes from the commander-in-chief power. But why did the Congress think they had powers over, the president had power over foreign affairs? So here I associate myself with the debate you heard at the first panel between Professor McConnell and Professor Mortensen. I associate myself with Professor McConnell's side. I think the explanation is that Congress understood that the president had foreign affairs power as part of the president's executive power vested by Article 2, Section 1. There's an alternative explanation, is that the Congress was referring to the specific foreign affairs powers that the Congress grants. But there aren't very many specific foreign affairs powers. There's really only three: ambassador reception, appointments, and treaties, and two of those are shared with the Senate. And there are a lot of things the president does in foreign affairs that aren't there are any of those. And the secretary, in the Foreign Affairs Act, was under the president's direction generally as to foreign affairs, not as to any specific matters. The final point then about removals, I think follows from all this. Why did Congress not specify removal power in these three acts? Again, I think it's because Congress understood that removal power was already vested in the president by the Constitution, and so Congress didn't need to give that power, either as to the secretaries, which was suggested by the way they phrased it, or, again, crucially to my mind, as to the subordinates. No removal power specified over the subordinates because they didn't need to. That was understood to be an aspect of the president's executive power. And that's all this paper says. It's a very limited conclusion. I want to be clear in closing that this doesn't show that the president's power in these areas couldn't be divested by Congress. Now, there are reasons to think maybe it couldn't, but they don't come from the 1789 Acts. That just wasn't an issue in 1789. Congress wasn't trying to divest any presidential power. So I think the starting point for this debate should be this assumption on Congress's part, is reflected in the statutes, that the president has military power, foreign affairs power, and removal power. And the question is, to what extent can Congress take those things away? And that's all.
Thank you very much, Mike. Jennifer.
Thanks so much. I'm Jen Mascott from Scalia Law School. Thrilled to be on this panel with a lot of esteemed executive power scholars, and thrilled to be out here at Stanford. So thank you all for taking the time to join us to discuss this afternoon. So my paper is an early draft, and it's titled and focused on what might at first seem like quite a narrow topic, the 1790 Sinking Fund Commission. However, I think that it ties into quite a few broader themes, both of which are topics on this panel and actually, pardon me, throughout the weekend. One is the character of executive power itself, because I think there are some questions about the character, the duties that this commission's carrying out. And then also it ties into themes that are going to be discussed by a lot of our speakers, like the removal power, and whether there can be limitations there, and how much the president has to have supervision over the executive branch and the exercise of governmental power. The particular reason for talking about the 1790 Sinking Fund Commission is that even though it sounds quite obscure, it actually came up and was briefed and mentioned by the Supreme Court in a recent decision in 2021. And so with that, I should also, I guess, make the disclaimer that Mike made at the beginning of his remarks, that my paper is also quite legal, as opposed to written in the typical history fashion, the discipline of history, and also is probably maybe even very specific to administrative law in a sense, because I think some of the conclusions hinge on doctrines that come up quite a bit in the context of the Appointments Clause and appointments and removal doctrines, which I think actually tie in a lot to executive power, obviously, and separation of powers, but are traditionally taught in administrative law. So in any case, what's the Sinking Fund Commission? Why is it something to talk about? Why did it come up in a 2021 case. Well, the 2021 case, Collins versus Yellen, dealt with the Federal Housing Finance Agency, and so the Supreme Court was trying to figure out if the head of the Federal Housing Finance Agency could have tenure protections. Could the president be limited and not just be able to fire the director of the Federal Housing Finance Agency, or was it fine to have tenure protections? And so curiously, even though the court has longstanding precedent from the 1930s that says multi-member commissions like the Securities and Exchange Commission doing quite powerful things, those folks can be protected with tenure rights where you can only fire them for certain reasons, that it would be more disruptive of executive power to ensconce the Federal Housing Finance Agency director with tenure protections, and therefore it's unconstitutional. Why did the court reach that conclusion? Well, because somewhat counterintuitively, although I think it's correct, the idea was that what we think of with accountability with a multi-member commission is that the actors themselves are keeping each other accountable. They're sort of a check. They can't actually, as individuals, exercise all that much power because they have to reach collective decisions. So if you have a single head of an agency, that person can exercise the full power of the agency. Therefore, if one has a view, the unitary executive view, and actually what I think is interesting, and I don't know if it'll come up as much on this panel, but probably could stand more discussion in debate today, is actually even what do we mean by that theory? Because there is a lot of scholarship that spends a lot of time trying to knock down the theory, but just in the little bit of research that I did going back looking at what's been said about the Sinking Fund Commission, actually the theory is described in quite distinct ways by many different people, and sometimes even as simply as, well, it means one person has to take all the action. Well, I mean, if we literally took that as true, that couldn't, no modern scholar could, I don't think, actually thinks like the president had to himself do everything by himself. Like just because there are collective actors making decisions, I don't think anybody actually really thinks that takes away the president's power. Although I think that there are a lot of folks who think collective actors need to be able to be supervised by the president. And why would we think that's ever a good thing? Why wouldn't that lead to corruption? Well, you'd have to have a theory of the Constitution that I think also, more broadly than what some folks are looking at, isn't just hinging on maybe the words themselves, clause by clause in the Constitution, but is hinging on the broader structure of it, the separation of powers. So I did say that I brought the phrase into the conversation here. And, elections, the electoral accountability of the president. Why would we ever, again, want the president to have power? Well, only if you think it's actually a constitutional feature and not a bug that the president's responsive to elections and representing the people, and therefore he or she would need to be able to maintain enough control so that when decisions are happening under that branch, there actually can be responsiveness if the people vote a person out of office or into office or whatever. My own personal view, which gets into the delegation debates of tomorrow, is that one of the reasons why perhaps it's a lot more frightening or controversial today to think about a president exercising that vast amount of power over the executive branch is because as a practical matter today, the president is probably, particularly if you see him or her as overseeing all of administrative agencies, doing quite a bit more than was being done in the 18th century. So perhaps our problem is more, Congress should be doing more, the executive doing less, and therefore putting one person in control of all that isn't quite as, splashy as it is today. But in any case, how does the Sinking Fund Commission relate? Well, the scholarship talking about it, I think, has made claims that the example of the Sinking Fund Commission, modest as it was at the time, can take down all of unitary executive theory in its wake, and so therefore we need to look at it quite closely. It came up in the Collins versus Yellen case as an example in theory of how maybe it was okay for there to be people running around at the founding who the president couldn't fire, and therefore the Federal Housing Finance Agency director didn't need to be fired. And there were financial transactions at stake with this commission, somewhat similar perhaps to what the Federal Housing Finance Agency was doing. So what did the commission do? Well, it was trying to pay down Revolutionary War debt. So it actually, I think also claims have been made that it had quite a bit of power because there's a provision in the statute authorizing the commission saying it can make regulations as it sees best. However, what was it doing? well, it had to, by statute, take the surplus revenue from duties and tonnage that were coming in the first Congress and apply it to pay down the principal of the Revolutionary War debt. So it was a matter of law and requirement, obviously, that the interest on the debt be paid every year. What was going to happen with the principal? Well, this was saying the principal, any surplus funds needed to be taken and applied toward the principal of the debt. Here's where the controversy, I suppose, or the uniqueness of this commission comes in. Curiously, in distinction to some of the executive agencies that Michael Ramsey was talking about, and there were only 3 executive departments at the time, Treasury, Department of War, and then the Department of State. This commission had a quite unique structure. It did not have a secretary sitting at the top. It did not have people where you necessarily thought they could just willy-nilly be kicked off the commission. It had actually representation from arguably 3 branches. Why do I say 3 branches? Well, it had the Chief Justice, it had the President of the Senate, who is also known as the Vice President of the United States, but curiously they chose to name his role on the commission as the President of the Senate, and then it had the Attorney General, the Secretary of State, the Secretary of Treasury, so 3 of the 4 kind of cabinet officials at the time. It did not have the head of the Department of War. So the purchases of paying down the debt had to be done by under the direction of these 5 people, acting either unanimously or with a majority vote. That said, they could only act with the approbation or approval of the president. So literally nothing could be done by the commission. The instructions could not be carried out unless the president approved of how it was done, and then the president also had some additional borrowing authority at the end. So in a certain sense, I mean, I do think it's really interesting, and there's a lot of interesting debates about executive power and the blending of power that I think could be spooled out here. Although, thinking about, I don't actually think this commission at the end of the day is really quite as splashy for the theory of executive supervision as some might portray it, because I mean, regardless of the type of power that's being exercised, regardless of whether people could be removed from the commission, if the commission can do nothing without the president approving it, if you believe supervision can be carried out through presidential direction, then I have a hard time understanding really what the problem is. So I guess that's thing one. Now, some scholars have said, well, the problem is that the president couldn't actually direct the commission to pay down debt. That is true. However, to have that theory and have that present a problem, you'd have to think that the president can force action. And if we see, I mean, the big debate here among scholars, I think, at this conference is how much residual does the president unilaterally have without Congress acting? But on the domestic stage, typically, you know, the president's not just engaging in domestic policy making on his or her own. I mean, Congress has to authorize offices, it has to create departments, it has to instruct the executive branch to do things. So we can just decline to instruct the president to do lots of things, including not authorize him to run around on his own and pay debt. It is certainly the case that if you look at financial transactions in the founding, there were unique accountability structures that were put in place to protect that. I do think that the founding era was concerned about financial corruption, so some officers had to come up with quite vast sums of bond if they were going to be handling money to even be able to serve in an office. As other folks in other papers have mentioned, the Treasury Department had a lot of subdivision of power so that there had to be multiple actors often involved in accounting and various transactions. I think you see that reflected here. They didn't want these market purchases of the debt to be done by one person who thought they were running around, you know, knowing how to do everything exactly right. I still think it had presidential supervision at the end. What about this idea of removal? Could the president remove anybody from the commission? Well, the statute doesn't actually specify and say that he could. So it's possible maybe he could not. They were just stuck on this commission, but if you held these positions, you were on the commission. Does that mean that he doesn't have any removal authority? Well, he could remove 3 of the people who served on the commission from their underlying roles just at the drop of a hat for no reason whatsoever. So some folks have said that's a problem because they can't be removed from the commission. I think probably that's not a problem. Number one, because in general, right, often Congress will authorize people holding positions to do a number of tasks, and we don't today necessarily think that the president could, for example, strip the Attorney General. Well, maybe we do, maybe some people do, but if let's say the Attorney General today has certain duties that he's carrying out, do we typically think of the president firing the Attorney General? Yes, or do we think of the president having power to say, all of a sudden the Attorney General, I'm going to take away from him command of the criminal division of the Department of Justice, and he can no longer act there? Probably probably not. So I'm not sure why it'd be that much more troubling to say, well, we can't take these people away from their commission role, even though we can fire them. True, it would make it harder perhaps for the commission to have a majority vote, but again, that just means the commission's struggling with inaction. There's not actually anything going on and being done outside of presidential command.
Jennifer, we are coming to the...
Okay, thank you. So the final thing is there a problem that we have this blending of power? Why are the why in a country that just ratified a constitution with 3 separate branches do we have the Chief Justice, the President of the Senate, and the executive officials acting here? And I think it actually raises questions about whether what the commission was doing was seen as carrying out executive power in the first place. The court recently in Modern Doctrine, and I think in the briefing in Collins versus Yellen, there's some opinion cited, has noted that not all things, tasks authorized by statute are necessarily exercises of executive power. If they're in the executive branch, the government can act as an employer, it can hire contractors. All these things are not necessarily delegated sovereign authority binding public people. Here, this was purchases involving federal debt, so it's not actually even doing as much, obviously, as the Federal Reserve is doing today. The other reasons to question, just as a matter of inherent inconsistency, whether this was seen as real executive power, there's no sense in which Congress assigning these people to sit on this board would have been in any way consistent with the Appointments Clause requirements for officers of the United States. Unless these duties were seen as germane to the underlying office, how could they be as the Chief Justice in charge of the courts? Is Congress authorizing him to exercise executive power? If so, there's a lot more probably problems than the Sinking Fund Commission. But I think that's interesting to think about. And why would Congress be able to just name and give these people power? Certainly, it was not done in compliance with any of the modes of appointment in the Appointments Clause. So anyway, these are some of the questions that the paper starts to try to explore, or at least point out, that I do think it's a very curious structure. I'm not sure that it leads to the undermining of all theories of executive supervision. Thank you.
Thank you, Jennifer. Jed.
Great. First of all, thank you for this panel of bringing together lots of different views. I think this is exactly what the conference was planned. This was one of the conversations that Michael McConnell and I wanted to make sure that this conference engaged with, was digging into the text and histories. I also want to make sure we want to thank Morgan Whalen. Where's Morgan? Morgan for being the person who did. This conference is actually here and working because of all the work that Morgan and other people did behind the scenes. So thank you. This is more than just delegation. It was true executive power of an executive director. So I thank you, Morgan. And I also want to thank the members of this panel who have been engaged with the debate about these issues. Jennifer and I were on a panel in the fall where we were talking about this, and Jennifer was very open-minded about, I don't want to put any words in her mouth, but she was acknowledging some of the weaknesses, and I think her open-mindedness about taking on the sinking fund is part of this. I appreciate Jennifer's open-mindedness about these arguments and recognizing the strengths of some of these new arguments, and so I appreciate that. Elon, in a recent article in the Cato Law Review, acknowledged some of the problems with relying on the decision of 1789 and was very generous in citing my work as raising questions about the reliance on this one, was very open-minded. And Mike has stood up and I don't remember any concessions, but I definitely appreciate Mike's frequent engagement with the arguments I've made, and among all the scholars, Mike, Elon, and Jennifer have been some of the most engaged and responsive, and I think that really deserves commendation. I think that
the audience at home.
Okay, now that all of my super appreciative comments were not recorded, now let me shift to the sharp elbows. I'm mostly kidding. I think there are 2 eights that I want to emphasize. The first set of 8 are the powerful evidence against the unitary executive theory these arguments have not been sufficiently addressed. And then the other 8, and this is where, to be honest, I would like to ask the panelists who are defending the unitary executive theory. 2 of the members of this panel submitted an amicus brief that cited the decision of 1789 and work that, frankly, was not reflecting the historical documents, and that misused and I think did not reflect what the debates in the first Congress actually said. And I think if you filed an amicus brief that makes these claims, I think I'd like to invite members of this panel to directly acknowledge or directly say where they stand on the decision of 1789. This is not a position I was looking for. I stumbled into this by asking another set of questions, but I think it's important that we look at the documents and and the use of historical sources by originalists as a degree of fact-checking. Here are quickly eight pieces of major originalist evidence that cut against the unitary executive theory. One, the take care clause. In the last panel, I asked Michael McConnell to go and suggest where the removal power comes from, and he identified the take care clause. I just want to raise the research that Ethan Lieb, Andrew Kent, and I did about the historical background back to the Magna Carta of the phrase faithful execution, that it would be surprising for this clause clearly had a duty-imposing power that was not part of the coronation oath. It was language for mid-level officers, and the language of faithful execution was a limit, imposed duties to the limit of good faith. It would be surprising for a duty-binding clause to create a power that was greater than the duty, meaning that for a power to be indefeasible and to be used with full discretion would be bigger and broader as a power than the duty to act in good faith or good cause. Good faith and good cause, I would say, are at least cousins. So I think one question is, the take care clause is not a strong basis for an indefeasible or unconditional removal right. Executive power did not include removal, and not just as a matter of Blackstone's list of prerogatives. I would raise the concern that nowhere in Blackstone did he mention the removal power as a power, whether or not it was a prerogative. Blackstone does talk about disposing of offices, and in an amicus brief that was cited as a there was argument that dispose meant to remove. No, dispose meant to distribute. Like to dispose of powers, dispose of offices was to appoint. Two, number three, the vesting clause. I have an article coming out any time now with the Stanford Law Review that shows as a matter of textual and historical evidence that vesting did not mean indefeasible.
Did not mean what?
Vesting did not connote indefeasibility.
Yeah.
This is actually a problem in the text, is that the Article 1 vesting, and this is where I might make Julian and Nick Bagley unhappy. This is, I think what's good for the goose is good for the gander. Article 1 says all legislative power, herein granted, is vested in a Congress. Article 2 does not use the word all. So what does that mean? In the article I have coming out, I say actually there is a textual basis for stronger vesting by the use of the word all. Maybe that means problem for delegation. But what do you make of the absence of the word all? So that's number three. Number four is the decision of 1789. I'll get back to that soon. I also want to, number five is Marbury versus Madison. In three separate passages, Chief Justice Marshall says that Marbury is unremovable as a matter of law by anybody. Why is that? I would challenge, it's not because he's a judge. He's not an Article 3 judge. He's a justice of the peace. And in Blackstone, justices of the peace are removable at will. Why not in America? Well, there's good historical evidence that Congress, like in the history of the common law, that offices for a term of years were unremovable except for by impeachment or high crimes and misdemeanors. Number six, the Federalist Papers. In Madison's Federalist number 39 and in Hamilton's Federalist number 77, they both reject removal at will by the president. So that's a concern. Then we've talked about the convention. 7 and 8 are about what we talked about with June 1st, about Madison and Wilson with the limits. And also, Gouverneur Morris proposed a council of state where he proposed at-will removal, and it was dropped at pleasure. It was proposed, and the convention didn't pick it up. So among those 8 pieces of evidence, they all cut against, that's the convention, that's the ratification debates, that's the Federalist Papers, that's the text, that's the history, all cut against the unitary executive theory. So to focus on the decision of 1789, the concern is about text here, is that the text of the text passed by the first Congress cut against the idea of presidentialism. Just to be clear about what the argument is, there were three different camps in the first Congress. There was the presidentialist camp that believed that Article 2 had already created a removal power. There was the congressionalist camp that voted along the lines for several days, and they were all together, they were voting consistently together in favor of a statute where this was the line passed initially. There shall be established the Department of Foreign Affairs, at the head of which there shall be an officer to be removable by the president. That's the text that was passed and then deleted. Why was it deleted? Now, Mike Ramsey cites what was actually passed, and it is more than ambiguous. It is silent about where the removal power comes from. Why would they delete the clear text? In my article, this is the history of the first Congress. What I found was that the diary of Senator Maclay, famous diary, has a lot of helpful context, but the unitary executive theorists who cite Maclay for the final vote tally didn't look at the shape of the debate in the summer of 1789. In brief, here's the timeline. During the House debates on the Foreign Affairs Act, when they passed the explicit language of to be removable by the president, which both presidentialists and congressionalists could agree on because it didn't say where the power came from, could be Article 2, it could be from Congress. What Senator Maclay documents happening that same week is the Senate digging in and fighting and rejecting Madison's proposal for the tariff bill that was Madison being pro-French and anti-English, and the Senate was more pro-English and anti-French, and they were at loggerheads. And suddenly it becomes clear that the Senate is digging in against the House on a particular issue. And Maclay talks about how there were lots of discussions and the Senate digging in. Lo and behold, the next Monday, and this is what I call in the article the Monday, June 22nd focus. I might also, if I were being more tongue-in-cheek, I'd call this Manic Monday. But on Manic Monday, Madison and Benson come back and want to delete the clear language and adopt the language that is silent on the source. It is not implied. It is just a contingency clause. That language, again, is, there shall be an inferior officer who, whenever the said principal officer shall be removed from office by the president, or in any other case of vacancy, and any other contingency, why would they drop the clear language for silent language? And it turns out it's not just my second guessing. Elbridge Gerry gets up and says, in the week before, he says, if you've got a theory, why not say it, right? Make a declaratory act. And he says, why won't they have a declaratory act? Because they can't agree, because they don't have a theory. He says this on June 17th. Instead of Madison and Benson coming back and adding a clarification, they add obfuscation. Why? Because the Senate didn't want to abandon its own power that Hamilton said they would have in Federalist number 77, which is that the way that you get into office is the way you come out. That's the classic Latin. And that is a power to block. Well, if you don't think you have the votes for a clear statement, this is what I call strategic ambiguity. And then lo and behold, in the House debate, the opponents accused Madison and Benson of being on retreat. They questioned Madison's manhood, literally, right? And then even the supporters concede that what we're trying to do here is, quote, this is Vining, we're trying to obtain the acquiescence of the Senate. They are telling you what they're doing. They're using ambiguity because they don't have the votes in the House for the unitary executive theory. They don't have the votes in the House for presidentialism. They don't have the votes in the Senate, maybe for any kind of, either congressional or. And so it turns out that I went back, and on page 62, I have a table that says that that shows when you look at these debates, especially when they finally had to split between presidentialists and congressionalists, the best case scenario is you've got 16 out of 53. You can check my math. I think 16 out of 53 is about 30%. So only less than a third of the House supported this theory. That's either an indecision of 1789, or if I want to make the stronger form of the argument, the first Congress rejected the unitary executive theory. They rejected presidentialism because they didn't, if I can quote Lin-Manuel Miranda's version of this, right? If they didn't have the votes, right?
Okay.
So that I think I guess I would like to see, given that evidence, and I'd like to hear from the panel
Yeah.
if they'd still rely on this on the decision of 17.
The other panel members should be warned. I will reissue that invitation of Jed's to disagree or to show why he's wrong disagreeing with you. Jonathan.
Sure. Can everybody hear me? Are we good? All right, great. Well, delighted to be here, even though I work here every day. Delighted to have everybody in town. This is wonderful, and as Michael said, to have so many people back together in person. So there's lots I could talk about. I'm going to try to keep my remarks brief. How much power did the President of the United States have, and what kinds of power did the President of the United States have based on decisions made in 1787 and 1788? That's one of the big questions we're wrestling with over these 2 days. And one particularly illuminating way to take up that question is to look to the first Congress and to the debates they had and the decisions they made to try to shed some light on that. And I think, as we can see from the panelists who have gone thus far, there's lots of different things you can do with the first Congress. There's a lot of rich and lively debates, which leads to rich and lively debates up here about how we should try to answer these questions. So to focus things, I think the clear area where the papers intersect is on the matter of removal and the removal power generally, and what that does or does not tell us more broadly about the meaning of executive power or the scope of presidential authority and what we should do with this. So I'm just going to focus my remarks mostly on this, and particularly on this debate in 1789, the first major constitutional debate that breaks out in the first Congress, over the removal of executive officers that several of our panelists have spoken about, that Jed was just referring to at great length, which is particularly focused on the question of removal. So I'll just offer sort of 4 observations to try to further open up the sort of lines of debate here, where Professors Werman and Professor Ramsey disagree on the meaning of executive power and what that gives to the president, but agree, if I understand them correctly, on the removal power being with the president. I gather from Professor Mascott sort of throwing herself in the camp with them on removal, although talking not about the decision of 1789 and the removal power in particular, but the sinking fund and delegation. And Professor Sugarman very much sharply disagreeing with sort of that take and what we ought to make of it. So I've written extensively on the decision, the removal debate of 1789. I find it endlessly fascinating. I love the opportunity to be able to chat about it. So I'll just offer 4 brief observations that also I hope at the end to suggest open up maybe some larger questions that Eric Nelson raised on the first panel about how we even frame some of these questions about trying to make sense of presidential authority. So first observation that comes to mind when I studied this debate. The debate was unexpected. People were really surprised they were having it. The debate breaks out, and it wasn't one they were preparing for or planned for. When Madison releases the statutory language for the bill setting up the Department of Foreign Affairs, and William Lawton Smith says, "What is this language to be removable by the president?" It takes a lot of people by surprise. This was something that they didn't really expect to be doing. 2, the debate was often treated as though it was covering new ground. So it's often assumed, for reasons that I think make a lot of sense, that removal is so important, it's so essential to the structure of the executive branch, that the delegates to the Constitutional Convention could not have forgotten it. That certainly sounds right, but there's seemingly no evidence from the removal debate, I think, that supports the idea that they didn't forget it. At no point during the removal debate did anybody so much as hint at prior discussions that apparently happened at the Constitutional Convention that suggested that even though you couldn't find the removal power clearly in the Constitution, that there had been some purposeful decision made somewhere along the line that explained why it was somewhere as long as you looked more closely. We don't find testimony of that kind in Congress. We don't find private testimony in the correspondence, either that's been published in the documentary history of the First Federal Congress or that which is not, which I've also looked at. Nobody speaks to, well, actually at the convention we recognized that removal was really going to be understood in these terms. We have other examples from the 1790s of this kind of thing happening. Alexander Hamilton famously wrote to George Washington in 1792 that he and James Madison had apparently taken a walk during the Constitutional Convention and said, should we or should we not enumerate a power in the Constitution empowering the federal government to assume state debts? And they both agreed, well, it would be risky on some level because it might lead to political backlash during ratification, and we don't really need to enumerate it because we're pretty confident the government would have it. If a similar kind of conversation happened pertaining to removal, we don't have access to it. It's unclear why there would be any incentive, as Michael McConnell mentions in his book, to hide the removal power. It doesn't seem like the kind of thing that you would need to sort of slide through the back door, or if the point that nothing was hidden, that removal was, say, just an obvious incident of vesting executive power in the president, nobody in 1789 said that that's what people thought in 1787. A lot of people said it was a necessary incident in the debate of 1789, but they didn't say that we all thought that, or some of us thought that, or many people thought that in 1787. When they referenced the proceedings of the Constitutional Convention, which only happens a couple times during the removal debate. James Madison talks about what happens there. Abraham Baldwin talks about what happened there. They usually talk more generally about how there had been great concern in the convention about how the Senate would have too much power and that the president needed to be protected from the Senate and from aristocracy. None of them make mention, for instance, during the debate of what Jed mentions, Governor Morris's August 20th proposal that was quickly forgotten and abandoned to create a council of states, 6 members of which would be removed during pleasure. Third thing that I observe about the debate, people's minds openly changed. They themselves said their minds changed. James Madison had one opinion in May of 1789. He had a different opinion in June of 1789 and said himself that his mind had been changed. Alexander Hamilton also changed his mind. In Federalist 77, he talked about the need for the president and the Senate to be involved in displacing executive officers. And when William Lawton Smith dramatically read from Federalist 77 on the floor of the convention, he was then passed a note the next day by Egbert Benson that said, in fact, upon mature consideration, Alexander Hamilton had changed his mind on the removal power and now thought it was with the president alone. And then the fourth observation I have that I think underscores something that Jed was really trying to draw attention to is the division and uncertainty, that there were a variety of different camps, none of which added up to a majority. So there's different interpretations, there's overlapping sort of allies. There's a majority that thinks the president should have the removal power, but they are divided over whether or not the president already has it by virtue of Article 2 or needs to be given it by Congress. So what I want to say in closing then is if you take these 4 observations seriously, I think one of the things they suggest that is important for us to keep in mind is that the removal debate was not merely wandering over familiar argumentative terrain, but was actually opening new terrain. I think it marked a key rupture in how people debated executive power. I think one of the reasons removal was overlooked to this point was because people tended prior to 1789 to focus debates over executive power on different things. The debate that the removal debate really brought to the fore, that has agitated constitutional law scholarship ever since, what is the meaning of the vesting clause? What does it mean to give the president executive power? That was not typically how debates over executive power in Anglo-America, on the American side of the Atlantic Ocean, tended to be focused prior to this point. Throughout the 18th century, I think the debate usually took the form, so this picks up on something Eric Nelson said in the morning, of not what did executive power mean so much as what are the right powers to give to an executive, which is a different question. And those were usually informed, the attitudes toward that question, which powers can belong to an executive, were usually shaped through not necessarily what they had read, although it was very important what they had read in Locke, Montesquieu, or Blackstone, but through their lived experience combating royal governors who throughout the 18th century wielded prerogative powers. And the debate typically took the form of, should an executive have these kinds of powers, and can an executive have those powers, and we will be free. Those powers tended to be very focused in nature, very specific prerogative powers, the veto, patronage and appointment, certain military powers. And I think as you get towards 1788, 1789, This continues to be the dominant way people think about it. So I'll just end by emphasizing two things that Professor Werman emphasizes in his paper that I think are really important. A couple of the state constitutions, Pennsylvania and Vermont in particular, who were written by people who were very, 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 very skeptical of executive power, have executive power vesting clauses that say the executive branch will have the supreme executive power. Whatever it might have meant, they clearly didn't think that it meant to give a far-reaching authority. And then when you get to ratification, Anti-Federalists thought Article 2 would create a monarchy. It was horrible. It was going to create this king, this figure, the President of the United States. They spent no time, none whatsoever, focused on the Article 2 vesting clause. They never said, he will be a king because of what's in the Article 2 vesting clause. They instead focused on those very specific prerogatives that you found beneath it, amazingly given to the president, a limited veto, qualified appointment power, and commander-in-chief power. So I think it's worth asking the removal, not just what the removal debate resolved or didn't resolve, but how it might have shifted terrain that from what kinds of powers should an executive have to more immediately, what is the meaning of executive power? People cared about that question before 1789. I don't want to suggest they didn't, but I think there's a shift in the first Congress that is important for us to keep in mind.
Thank you very much, Jonathan. Aditya.
Thank you so much, Professor Casper, and thanks to, sincerely, to Michael McConnell and all of his colleagues at the Stanford Constitutional Law Center, and to Professor Sugarman for organizing this event. It's really great to have this exchange of views on this important topic. As you gathered, I think, from the remarks already on this panel, the question whether the president has power to remove other executive officers is really one of the most foundational and famous in American law. It's been at the heart of American government and constitutional debates almost since the beginning of the creation of the American government. And with a topic like this, given truly vast quantities of ink that has been spilt on the subject, it would be impossible to do justice to the subject in anything short of a book-length treatment, which is why I'm so grateful for Professor Casper for allotting me the next 1 hour to speak on this, on this topic. Yes. No, that's just kidding. I'm not going to be able to cover every nook and cranny of the subject, but rather I'll sketch out just a few responses to some of the remarks that have been made already on this panel. Specifically, I guess what I'd like to speak about is pre-existing British practice, number one. Number two, Marbury versus Madison. I'll talk about that. And then number three, if there's time, and perhaps there won't be, I'll talk about the 1789 debate and just what I take away from that. So that's my plan for the next couple of minutes. All right, so pre-existing British practice, it's actually, I think, quite interesting and poses the following puzzle, which is that the British Crown had long been understood to have the authority to set the tenure of officials, choosing among various options, such as to an individual and heirs, for the officer's life during good behavior or during pleasure. And what happens is that over the course of time, specifically during the 18th century, there is a rise of what we now would describe as parliamentary supremacy in Britain. And that meant that the legislature asserted authority to regulate offices and to fix tenure of offices. Nevertheless, despite this form of legislative supremacy, which effectively authorized Parliament to strip the Crown of any of its authorities, from pardons to appointments, the earlier British tradition had lingered, and it had created this vocabulary that deemed certain powers to be executive. And in this respect, I think I share ground with Professor Mortensen from his article, and Professor McConnell and Professor Werman, who have different views about the scope of executive power, but I think share there's a shared ground there that there was a vocabulary that had developed that reflected these pre-existing practices. And what that means is that these powers that the British Crown had or lacked at the time of the Constitution's adoption, they weren't immediately transplanted into the president, I don't believe, because the president was not the British king and had fewer authorities in various ways, but Congress also was in Parliament and didn't possess the same sort of supremacy that Parliament had. And if there's time permitting, there are a couple of interesting quotations from the debate of 1789 that speak to representatives' usage of British practice, and I'll cover them if there's time, but just to gloss them without actually quoting them, what I would say they reflect is a misunderstanding of the actual British practice at the time the Constitution's adopted, in the sense that all the nuances that have been covered by recent scholarship, of which I'm an admirer, are actually not captured by some of the representatives. They perhaps have a slightly mistaken view of what the British practices were. And then the puzzle, to return to where I started, is what do we make of that? What does the Constitution mean when the people who are interpreting it and perhaps writing it, maybe they just actually don't know what the British practice is. They have a different sense of British practice than what is reflected on the ground. So that's what I wanted to say about the British practice and the British Crown that preceded the enactment of the Constitution. All right, second point on Marbury. And I think this is a very interesting point as well. So if you will indulge me, I'll probably go into a little bit of detail here, and we'll get to 1789 if there's time
I
permitted.
remind you that you always say, if there's time, there is no time.
Fair enough.
So remember that.
Okay, so that's fine. I'm happy to end with Marbury if in fact that is the best place to end. Well, I do believe actually that Marbury is quite explainable, and I think that there are challenges with respect to the decision of 1789, as there are always challenges with legislative debates and trying to understand the motivations of different legislative actors, which is an interesting broader point about the usage by courts of non-judicial legislative precedents. But Marbury is explainable. So just to remind us, Marbury had significant political repercussions at the time, not necessarily with respect to its judicial review provisions, but rather the appointment and removal allusions that Chief Justice Marshall makes in the first two parts of the opinion. So what happens? After discussing appointment at great length, Chief Justice Marshall says that John Adams had appointed various parties as justices of the peace. And in contrast, he then speedily concludes that presidents cannot oust these justices. And the D.C. Organic Act, which created the office of Justice of the Peace, proclaimed that the justice could serve 5 years. According to Marshall, the justices held office, quote, independent of the executive, and, quote, the appointment was not revocable, but vested in the officer legal rights, which are protected by the laws. Okay, so what's happening here? I think there's a good argument, and it's reflected in contemporaneous sources, that Marshall's removal claim depended on the status of the justices of the peace, either as Article III judges or alternatively as distinctive officers serving in the federal district. For Article III judges, obviously the Constitution limits presidential removal by granting good behavior tenure. For territorial and district officers, Congress arguably can grant tenure protections. If Marshall's reasoning in Marbury was limited to one of these special cases, then it doesn't have implications for executive officers more generally. And now I will, of course, agree that actually in the opinion itself, there is no evidence about these special cases. There isn't the argument that is made to the court. And I believe Professor Sugarman is aware of that because he mentions it in his article. What he doesn't mention is that there was a case decided by the DC Circuit the very same year Marbury was decided, and that's United States versus Moore, which goes to the Supreme Court on another basis. It's a very famous case. And so what had happened along with Marbury at the same time was that the Jeffersonians, who remember had just taken power, this is after the election where Jefferson defeats John Adams, reduced the fees available to be collected by the justices of the peace. And that abolition might have been an unconstitutional salary reduction had they been Article III judges, okay? And this issue gets litigated to the DC Circuit, and there is a majority opinion that is written by Judge William Cranch, of course that's the Cranch who's the reporter, and joined by James Markham Marshall, that is, of course, the Chief Justice's brother, and they reason that the justices of the peace are Article III judges, okay? And the dissent in the case, which is written by Chief Judge Kilty, it denies the point and it claims that the justices of the peace have a special status as DC judges, so their salary can be reduced. Neither the majority nor the dissent nor the parties argue that because the justices are ordinary executives, Congress has undoubted power to cut their fees. And to kind of put the point home, Cranch's reasoning tracks the attorney for Marbury, Charles Lee's reasoning in his argument, And it echoes Moore's attorney Samuel Jones, who's an eminent lawyer within New York. And Jones acknowledged, and he actually says this in his argument, that the president's power to remove had been, quote, settled in Congress in the year 1789 after a long debate. He further admitted that, quote, Congress has no power to limit the tenure of any office to which the president is to appoint unless in the case of a judge under the Constitution. But Marbury, according to Jones, had decided that, quote, a justice of the peace in the District of Columbia does not hold his office at the will of the president, and Jones insisted that a justice of the peace was an Article III judge. Jones claimed that it was, quote, no objection that the tenure of office is limited to 5 years because it was not the tenure, but the essence and nature of the office, which is to decide this question. He's arguing basically that the 5-year limit is unconstitutional. He thinks that these justices of the peace are Article III judges. There's actually another persuasive argument against overreading that language in Marbury, which is that, in fact, people do contest that Marbury bars removal at the time, and President Jefferson removed some of the justices of the peace from office. But I'll just bracket that in the interest of time. And let me just close that Chief Justice Marshall writes a book 4 years later after Marbury's called The Life of Washington, and he describes the decision of 1789 in 1807 in the book, and he says, to obviate any misunderstanding of the principle on which the question of removal had been decided, Mr. Benson later moved in the House to amend the second clause to the bill so as to clearly to imply the power of removal to be solely in the president. And the paragraph goes on describing the debate and its conclusion. But I'll stop right there, and I'll just say this is very interesting material. I think there's a lot more to talk about, and I'm really very grateful to all the panelists, including ones with whom I might share some disagreements, because they are the ones who push me to become a better thinker on these topics.
Thank you, Aditya. Remember that if somebody asks you a question, you may get a little more time. So,
Well, thank you.
I will stay with the panel. Ladies and gentlemen, who wants to take up the challenge that came from Jed to all of you? Yeah, I thought you would. Okay.
Thanks, and just for the sake of posterity, since this is being recorded, Jed's challenge, I think, was principally to me as the lead author of the brief that he criticizes, and so
It's equally for the entire panel, really, yeah.
So fair enough, but nevertheless, as the lead author of that brief, and I stand by 99% of it, Jed has convinced me of two what I think of as minor issues, but nevertheless, things that should be corrected, and the record should be corrected, and I've corrected them publicly elsewhere in writing, and if I get a chance, I'll do it now. Jed, with apologies, I only got the first 6 of the 8 that you said, so let me just go through those sort of in reverse order and just add a little to what Professor Bamsai said. First, number 6 was Federalist. It's true that Hamilton in Federalist 77 seems to suggest that possibly the Senate, which has a role in the appointment, will also have a role in removal. But that is not a necessary interpretation at all of what he says in Federalist 77. And in fact, I don't think that's the best interpretation. What Hamilton seems to be saying in Federalist 77 is that the Senate will be a check on removal, because if a new administration removes meritorious officers from a previous administration, the Senate might be a check on that in their refusal to make the new appointments. Okay, that's very different. That is perfectly consistent with the appointment power. Let me read it to you, and you decide if I'm right about this. It has been mentioned as one of the advantages to be expected from the cooperation of the Senate in the business of appointments that it would contribute to the stability of administration. The consent of that body would be necessary to displace as well as to appoint. Right? That's the ambiguous language. A change of the chief magistrate, therefore, would not occasion so violent or general a revolution in the officers of government as might be expected if he were the sole disposer of offices, again, the sole appointer of offices, where a man in any station had given satisfactory evidence of his fitness for it. A new president would be restrained from attempting a change in favor of a person more agreeable to him by the apprehension that a discountenance of the Senate might frustrate the attempt. Okay? That seems to be in the context of appointments, which again is not controversial. Madison did say that the Congress has a say in the tenure, regulating the tenure, and so it does. Congress sets qualifications for offices, it establishes the offices, and it can say U.S. attorneys shall have 4-year terms, after which they expire. Why is this important? Because after the term expires, that means you must go to the Senate again. Okay? That doesn't mean anything about removal, certainly not necessarily. So that's an answer there. On Marbury v. Madison, let me just add, I agree with everything Adit just said. But if Jed is right, that the implication here is that Chief Justice Marshall said that William Marbury had a property interest, a property right in his office, okay? I think that means Congress must have the ability to create a lifetime federal prosecutor, a hereditary federal tax collector. That is the implication of saying that executive officers exercising the executive power of the United States have property interests in their offices. That is totally violates the separation of powers to bring it in, and everything we think and know about how the Constitution works. And so this, well, I posed this issue to Jed on Twitter yesterday, so hopefully he's had time to think about it and has a response to that. 1789, let me pass through that. Let me say—
Well, I mean, Ilan, that's what if I may.
Oh, 1789?
My challenge is solely on the first Congress. Can one cite a quote, decision of 1789 as a decision in favor of unitary presidentialism?
Yeah.
That's my only question.
So I'm going to say, yes, it can be. Is it compelled? No, it isn't a compelled interpretation of what happened in 1789, and Jed knows, because I say this in the Cato piece that he mentioned. I am less firm on 1789 than other formalists have been, but let me just say that this idea that the majority in favor of giving the removal power to the president in 1789 was cobbled together by two separate factions, a faction believing in an indefeasible presidential removal power and a faction believing that Congress has discretion. That insight is not new, right? It was made by Brandeis in his dissent in Myers against the United States. It was made by Edwin Corwin in the 1920s. It was rediscovered by David Curry in the 1990s. I grant with Jed that formalists have put too much weight on the decision of 1789. But I've read the debates. I've read every single page of those debates. And by my count, more than the third that Jed talks about thought they were making a constitutional decision. We interpret passages differently. That is a scholarly and academic debate, and that people can disagree about. But is it fair to use it as evidence? Well, I think as Aditya shows, it certainly became to be seen as sort of this permanent exposition of the Constitution, rightly or wrongly. It became very quickly to be taken for the proposition that I think Marshall made in his Life of Washington. I've got things on vesting executive power and take care, but can I keep going?
You're good. Yeah. Thank you, Ilan.
Okay.
Any other member? Yeah,
Yes.
Jennifer.
You want to take off where I left?
Sorry?
Well, I was just going to say it's totally different. I mean, you all are arguing about, I guess, how the majority view should be read, but is it not the case that even if there were only 16, that's still powerful evidence in favor, perhaps, of unitary executive theory? Because number one, at least they were debating the issue, so it was in someone's consciousness. And also remember, these folks, it would be totally against their interest to not be able to impose removal limitations. So is it not actually quite significant that 16 of them would think they were limited in legislation they were able to impose on the executive branch? That's just thought. Michael, did you have something?
Jed, you want to respond?
I do, because I think it's also responsive to Aditya citing Chief Justice Marshall. I mean, this is sort of the insight of Darrell Levinson and Rick Pildes of separation of powers and not separation of parties and not powers. It is not against an interest if parties are forming. Everything you've described is a Federalist insider. And this is what I'm focusing on in this paper. What Senator Maclay is highlighting in the summer of 1789 is the forming of, and I use this word because he uses it, even if it has some connotations that I think are troubling. He describes a capital cabal, that there's a court party versus a country party. And Jennifer, I appreciate that you're saying it's against their institutional interests, separation of powers, but this is the insight about the separation of parties. The Federalist Party is not formed is not fully fledged, but the 16 members of the House that are presidentialists are Fisher Ames, and that name is familiar among the arch Federalists. That party is that is a partisan interest. That's the court party saying, we as Washingtonian insiders, I mean, it's not DC Washingtonian, it's George Washingtonian in New York. But my challenge to Aditya is, Aditya, that's exactly what I'm saying. I'm saying that what has happened is the way the decision of 1789 became the story is the victors write the history. And the victors are the Federalist Party, and Chief Justice John Marshall is telling is spinning. This is all spin.
So you don't think it's fair to use the first Congress debates as evidence of any original meaning?
No,
Because
I
it's
didn't.
all,
I didn't.
well,
I'm
it would all be tinged by this, wouldn't it?
Well, so this is I think this is a broader debate about whether the first Congress, Will Bode was coming to this conference and I think there's this question I think he's acknowledging the challenge of what liquidation means. But I think it is important to separate out the first Congress as what's helpful, but with a grain of salt. It is helpful as elaborating original public meaning, and you have to take it with the partisan grains of salt. In this case, what I would say is, the debates at best show 16, but even the 16 are dubious, because many of them are voting strategically because they're trying to use strategic ambiguity regardless of it's only a handful of people, and two that are making a presidentialist argument. Madison and Fisher-Ames, Elon, you cite Fisher-Ames and Madison. Sai Prakash acknowledges that Fisher-Ames gives both theories. Fisher-Ames says, I'm voting this way because I believe it's both. It could either be Article 2 or it could be Congress's power. And he cites Ames as having a mixed, so your reliance on Ames is actually about the wanting it both ways and lack of decision. So I think I would cite the 16 on the one hand and the fact that there were at least 30 who were opposed to those 16 as the rejection of the presidentialist theory.
Thank you, Jed. I will call on Jonathan now, and after Jonathan, I will call on the audience.
Well, excuse me, I would like to make a comment, if it's all right, because Jed addressed a challenge to me.
Okay, you will get to
and
make a
I would like to
comment
be
after
able to
Jonathan.
make a response
After
to what
Jonathan.
Jed said, if that's all right.
Yeah,
I mean, I don't.
you will get to make a comment after Jonathan.
Well, part of what I was going to say, I think, was actually teeing up Professor Ramsey, because I take one of the things you're trying to do in your paper, which is interesting, is to focus on what was done rather than what was said. And part of that raises classic questions in law and interpretation about which things we focus on, and can you figure out what they did without understanding the broader debate? And I take that to be part of what you and Jed are arguing about. You're trying to interpret the statutory language in a decision. So it's an invitation for you to maybe speak further on that, because most people who have made your argument in the past have focused more on the debate, if I think that's right, and you're trying to shift ground here. So there's a sort of methodological question there that I think is interesting, and what relationship to what do we do with the first Congress and what it can tell us about original meaning, given that it's highly partisan. So that's one way. You look at what they did rather than what they said, but what do you have to how much can you know about what they did from the statute? And in this particular case, do you really have to know the debate? I think there's some really important questions to unpack there.
Mike.
Well, thanks, and I apologize for dragging this debate out. I thought, though, I might make a couple of quick comments as a signatory to the brief that Ilan was the lead author on. The challenge is addressed to me to some extent as well. And I just want to give my own perspective on what the decision of 1789 tells us and doesn't tell us. So, Jonathan, I appreciate that, teeing that up. And I did want to focus on that. And I think that first, just the statute, I think, tells us that Congress didn't give the president power to remove. It's not in the statute. So the president has to have, I think, a constitutional power to remove, or else the people would not be removable. And that's, I think, not a plausible interpretation of the statute. Now, that doesn't answer the question of whether the Senate has a role in the removal or not. It just says that Congress doesn't have to, by statute, convey the removal power. So that's point number one. All right. And then I think that's all we can get out of Congress. I don't subscribe to the view that we can count noses in the first Congress and decide what the constitutional answer is, because there were, as Jed says, a lot of institutional cross currents, and I don't know what all those people were thinking, nor do any of us know. But we do know one thing, which is from the debates, which is that Madison provided an explanation for what was going on, why the removal power was in the president. And I find that explanation to be persuasive as a textual matter. So that's the second point. So the first point is that the Congress didn't give the president any removal powers. It has to be in the Constitution. The second point is that Madison gives a plausible explanation for why it's in the Constitution. And then here, the final point, which I think is a critical one, and we talk about the decision of 1789, to me, that doesn't mean what Congress voted. Because Congress can do lots of unconstitutional things, including in 1789. So what matters to me in 1789 and thereafter is that thereafter it is understood that the president has removal power. And the president removes executive officers. And just to pull it around to foreign affairs, he removes ambassadors. And there isn't any congressional authorization for that. And he doesn't ask the Senate for its approval, and the Senate doesn't object. So to me, the decision of 1789 is not just what Congress did, but it's also what is accepted at the time by all of the actors as the appropriate constitutional procedure. And that is the decision of 1799 to me, and that supports the view of presidential removal power as a constitutional power. That's what we said in the brief, or at least that's what I understood the brief to be saying. And on that basis, I signed the brief, and I find it to be of continuing persuasiveness.
Thank you, Mike. Now, showing flexibility, I now call on Aditya before I call on you.
It's very kind of you. I'm sorry to prolong this. But I thought it is interesting to think about the victors and the losers, because that framing will always exist for non-judicial precedents. There will always be the possibility that some legislators were motivated by reasons that they didn't express on the record, or that they were pursuing a certain goal because they liked President Washington or they hated President Washington. And it's something, I mean, I think to think about more broadly, not just about this debate, that's always going to be a possibility. In this instance, I gather from the paper that I reviewed for the conference that Professor Sugarman says the victors were Washington, Adams, Hamilton, John Marshall. I'm happy to stand with those victors. You know, those are good victors in my view. Now, there were, in fact, and this is really something I learned from Professor Sugarman's paper, which is great, there's overlooked evidence from anti-presidentialist senators, Payne Wingate and Richard Henry Lee, that concedes defeat on the constitutional question, which is a statement against interest. So it's not the victors in that case speaking. And the paper suggests that Senator Wingate was unsophisticated, Senator Lee was perhaps confused. Let me just point out that Wingate was a longtime member of the Continental Congress. He's later a justice on the New Hampshire Supreme Court. He's no legal slouch. And Lee was also a fine lawyer. So it's interesting that they thought that they'd lost on this constitutional question. By contrast, I think that Maclay, for example, Maclay's been, whose diary is an important source for Senate deliberations of the first Congress. I agree. But Maclay was one of the most radical members of the anti-administration faction, and he's known for being prone to exaggeration and ad hominem. So he constantly feuded with John Adams in the Senate, allegedly because Adams had rejected Maclay's political deal to support his vice presidential candidacy in the preceding presidential election. And in Congress, he was best known for attempting to establish the site of the U.S. permanent capital near his own land holdings on the Susquehanna River, instead of what became Washington, D.C. He was then in office for only 2 years because the Pennsylvania state legislature failed to re-elect him. And I'll note that he was replaced very, very briefly by the great Albert Gallatin. So it's an interesting history over there as well. I will stop right there and
Yeah,
just say
okay,
that
good.
this is something well worth thinking about because I think it's a complicated topic that we need to speak more on.
Thank you very much. Now I will call on the audience to make questions or comments, of course. Disagree with everybody.
I think Julian is the only person brave enough to ask a question after that panel.
It's a question that's going to be very open-ended. I want to briefly read a passage from the North Carolina Ratifying Convention and then sort of see whether you all think that you can make sense of this passage on the various perspectives that you bring to bear on, in particular, the vesting clause. They turn to Article 2. First part of Article 2 is the executive power, and they start working through Article 2 in sequence. We know, coming back to, I think it was Professor Nelson's comment about silence when the issue was first introduced in Philadelphia, we know from the record here that there was a silence when they said, all right, time to talk about the executive power, this first clause, because the first recorded comment after what appears to have been an uncomfortable long period of silence is from a Federalist, a leading Federalist in North Carolina, William Davie. He says, "What is the cause of this silence and gloomy jealousy in gentlemen of the opposition? This department has been universally objected to by them. The most virulent invectives, the most opprobrious epithets, and the most indecent scurrility have been used and applied against this part of the It's fun to imagine him, right? It has been represented as incompatible with any degree of freedom. Why, therefore, do gentlemen not offer their objections now, that we may examine their force if there is any?" The clause, meaning the executive power. That's where they are as they walk through this. Not all the ratifying conventions were so organized. North Carolina did it like clause by clause. "The clause meets my entire approbation. I only rise to show the principle on which it was formed. The principle is the separation of the executive from the legislative. The separation of the executive from the legislative, a principle which pervades all free governments." So the response to this challenge, say something about the vesting clause, tell me why you're worried about it, is nothing. And they move on to the other elements of Article 2 and have like vicious, scurrilous, virulent, opprobrious debates about the veto power prerogative, about the appointment power, right? Like, plausibly maybe some to do with the executive power, but certainly a prerogative. So I'm curious how you all think about that exchange, what it tells us about the vesting clause, and then how it bears on some of the discussions you've had here.
Thank you very much for the question. Who would like to answer? You don't need to have, all of you need to answer, but some, sure, Michael.
Well, I'll answer because I think, at least in part, that's directed at me in connection with the foreign affairs power, which Julian and I have discussed. And so, but it lets me make a broader point about the residual executive, and the implication being if the president had these residual executive powers out of the executive vesting clause, why weren't the anti-federalists upset about that? I think so. That have been, and Julian, thank you for that clause and for that debate, and I think that illustrates something that is important to me about the executive vesting clause, but it's not necessarily shared by all theorists of the executive vesting clause, and that is, I don't actually think that the powers that clause conveys, even though I do think it conveys some powers in foreign affairs, for example, I don't think those powers are actually all that great. I think they're mostly powers over diplomacy, communications with other countries, making policy announcements that are really not that big a deal. The framers stripped out all the big foreign affairs powers that the king had exercised, treaty-making power and the war-making power, and assigned them elsewhere. So what was left really wasn't that scary. So I think the debate you read makes sense. They weren't. This is why generally the executive vesting clause wasn't a target in the ratification debates, because people really weren't that worried about it. They just thought it made sense that the president would have these sort of incidental foreign affairs powers, and people were worried about other things. So that's what I take away from that.
Thank you.
Thanks. I just wanted to make a comment, really an observation, and it's a reaction I have when I listen to debates like this one, which is extremely interesting and illuminating, and it has to do with the evidentiary base that many of the comments are drawing from. So I think it's important to remember that when we look back at the debates in the first Congress, we're not looking at verbatim transcripts. What are we looking at? Even the very best compilation, the documentary history of the first Federal Congress, Ken Bowling and the other editors make clear that what they are doing is they're cobbling together newspaper reports, essentially, of those debates. We are relying on people like Thomas Lloyd and Archibald MacLean and other people whose names we don't know, who were present, who were taking down shorthand notes, who were publishing these reports in a bit of a scattered way. There does seem to be some cases where members of Congress were feeding the journalists texts that they wanted to appear, but others didn't. Just think it's important for us to be cautious in drawing inferences about the views of particular members of Congress, the consistency of their views, whether they had a constitutional theory, what they were doing. I don't know what kind of evidence the Supreme Court had when they decided Myers, because they didn't have the documentary history. I'm kind of curious now, what were they drawing from? I just think we all ought to be a little bit careful. I offer that not out of any position. I'm in the same position. I do the same thing when I do my work. I'm not trying to suggest otherwise, but just a kind of an observation along the lines of some of Jonathan's observations about where we are when we're having these debates.
Thank you for this appropriate warning. Yes, sir.
Hi, my name's Dave Paul, private citizen, unaffiliated. During the first panel, there was a reference made by one of the members that I thought was very appropriate, and that had to do with at the time of the Constitutional Convention that there was an expectation that a person could study, reach conclusions, debate, and that meant that they could stand and justify their position as well as defend against opposition. So you had to be an individual in order to join the group. What do we see today? I think our moderator was hinting at this at the beginning of this discussion, but I might be putting words in his mouth. I'm speaking for myself. Let me make that clear. And that is today, histories, plural, not singular. In other words, have we abandoned the pursuit of truth and in order to have our present infatuation with multi. In other words, multiple points of view that cannot be determined true or false. This is kind of like what we have with committees today, where people will sit on a committee, they're supposed to reach some consensus pleasantly, and then they submit one opinion as a group. Life is a committee? No, I'd rather be an individual. Thank you.
Thank you. Would anybody like to respond to that? Yeah?
I'll just say one quick thing. So I appreciate those comments, and consider myself an originalist, and so I do think that we can learn things from the historical sources. And I think the people who would traditionally call themselves non-originalists, who are now steeping themselves in the historical sources, or always have, and are debating originalists on originalist terms, I think in some sense suggests that they too think that we can have better or worse answers, and possibly even right and wrong answers to certain things. And so I do wonder if this is a change in historical method, or at least in the legal academy. I do think there are more people who traditionally would consider themselves to be non-originalists who think it is possible to arrive at correct historical originalist answers. They just think that all the originalists are wrong about what those answers are. But I think that's an improvement.
Thank you. Anybody else from the panel? Yeah.
I'll co-sign with Elon on that. I think originalism is the worst form of constitutional interpretation, except for all the others.
Any other question? Anybody else who would like to ask a question? No? Well, If not, I will call this panel to an end. Thank you very much. I thought it was fascinating. And we will meet again at 3:30, I assume, or a little earlier. Sorry, 3:30. Yeah, at 3:30 again in this room. Thank you very much.